It is now 4:01. I will call the City of Elkhorn Zoning Board of Appeals meeting to order today, November 2nd, 2023. Are we going to do a roll call, Sherry?
Yes.
Okay,
Stockel,
great.
Here.
Boardman,
Here.
Welsh,
Here.
Skelton, Dushman.
Do we have a quorum?
Yes, we do.
Wonderful. I will take a motion and action to name a chairperson at this time.
I can make a motion for Jim Boardman.
No second.
I'm not gonna second it.
He did. Tom did.
Okay, wonderful. We have a motion and a second.
Jim, you want to come up here where the gavel is? You're running the meeting.
I got a
Do I need an all in favor?
Oh, okay. Yeah, I'm comfortable.
Yeah, I would, Allison.
Okay.
All in favor?
Okay, all in favor?
Aye.
Aye.
Okay. Jim, I will let you take it from here.
Okay, motion to adjourn into a public hearing and read the public notice, which I don't have a copy of.
I've got one.
Oh, here I do now, okay. Notice is hereby given that a public hearing will be held before the Board of Appeals of the City of Elkhorn on November 2nd, 2023 at 4 p.m. or soon after as the matter may be heard in the council chamber, City Hall, 311 Court Street, Elkhorn, Wisconsin, for the purpose of hearing all interested parties in their attorneys or agents with respect to this request submitted by John and Jaylyn Olson to allow for a sunroom addition located within the front yard setback of the parcel. Section 17.7-3 of the Elkhorn zoning ordinance states addition in the street yard of existing structures shall not project beyond the average of the existing street yards in the abutting lots or parcels. The property is located at 115 South Broad Street and is more precisely identified by the following tax parcel ID number YRW00051. The City of Elkhorn will attempt to accommodate anyone with special needs if requests are made in sufficient time in advance. Okay, I would ask at this time then comments by the zoning administrator.
Hold on, I'm sorry. You still need to make a motion to actually hold the public hearing. There's not, the public hearing hasn't been convened yet. There needs to be a motion and a second and a vote.
Need a motion to adjourn to a public hearing.
Yeah.
Make a motion.
Second?
You want to second it?
Yeah, oh yeah, all those in favor say aye.
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 Okay, now we are in a public hearing. And I ask for comments by zoning administrator. Allison?
Sure. Just to clarify, do we need to, at this time with the public hearing notice, do we need to hear any citizens present? That would be a question for legal.
Yeah, your agenda actually has your comments first before the presentation by the petitioner or the agent.
Okay. That sounds good. I just wanted to make sure that there were not, that we were not missing anything, but I will go ahead now. Thank you so much. So enclosed in your packet tonight, you will see several different items, a application that was submitted by the owners of the property located at 115 South Broad Street, as well as a denial letter and then a petition for a variance. The applicants did come in, they requested a building and zoning permit for a small addition in the front yard of their property. You will see that currently they have an existing deck in that space. The existing deck is not enclosed, it's just a wooden deck, and the applicants were requesting to turn that area into an enclosed screen room by adding an addition onto their home. It would be an attached structure, attached to their existing home. In doing some further research, I found that the property's zoning designation required a 25-foot front yard setback requirement for all principal structures. The addition that they were requesting was 21 feet instead of 21 feet or 25 feet. So 21 feet instead of 25 feet. So they were 3 feet away from meeting the code requirements. We looked into doing setback averaging, which is allowed per our code, but only allowed by taking the abutting properties setback averages. Right now, the two properties on either side of 115 South Broad Street meet current setback requirements of at least 25 feet in the front yard. The rest of the addition does meet code. It is only the front yard setback distance of 3 feet that is in current non-compliance with our zoning ordinance. Therefore, I did need to move forward and deny their application, giving them the option to apply for a variance. You'll see there in that photo that Matt has up on the screen is the existing condition. And I think that's all for now, unless there's any questions.
Okay, presentation by the petitioner or, go ahead. You can either sit or as long as you grab a microphone, please.
Well, she has to speak into the microphone.
Yeah, we gotta get the microphone. You need to sit at the desk here if you're more comfortable way.
Thank you. That way it gets captured in the recording.
Okay, I'll sit here. So I guess my thought is, I purchased this home in the early 2000s, and at that time, that deck was existing, as well as a deck that went in the front of the home. In 2017, I came down here and I got a permit to put that addition on, and at the time told him that eventually I wanted to enclose that room. I was given that permit, and the reason was he said that there was already an existing structure, so I was not doing an addition, I was improving what was there. So I guess that, and then I realized it's kind of not good for me, but there are 9 houses on that block. 7 of them are less than the 25 feet. The only 2 are the 2 on the sides of me. So I guess it's not an addition. We're requesting to improve what's there. That's it.
That's it, huh? Okay. All right.
Unless you have questions. I mean, yeah, it's not, it needs to be addressed. It's getting to the point where it was built before we bought the house in the 2000s. So it's getting to the point where something needs to be done with it. It either needs to be rebuilt, and we figured since we're doing that, it would be great to improve it instead of, but yeah, it's not, we don't want to, and actually what we want to do is a couple inches less than the existing deck, so.
So actually, that would not protrude any farther out than what the steps do now?
Oh, no, it would be a little less.
Okay. Any comments by interested property owners or agents? Yes, Jim?
Up here?
Yep. State your name, please.
Yep. My name is Jim Gerlach. I live at 12 North Church Street here in Elkhorn. And I'm sure some of you remember back in July, Julie and I were here asking for a variance to expand our garage. And during those proceedings, as we're getting near the end of the proceedings, Ward Phillips, the city attorney, spoke up and said he didn't think it caused a hardship. I was kind of taken aback by that because I didn't think Ward Phillips was part of the board. I didn't think he was supposed to speak at all, let alone have an opinion as to whether or not we should be granted a variance or not. But didn't think it was a hardship, and I was hoping he would be here tonight because I did want to invite him to come to our house and try and put his car in our garage. And then he might be able to speak intelligently about whether or not that's a hardship. But right after he spoke, Tom spoke up, and you asked Allison, is if what we were asking for is against city code. Allison responded in the affirmative. Yes, it's against city code. You raised your hand and you said, if it's against city code, we can't approve it. I make a motion we deny. Bing, bang, boom, we were denied. I thought, what the heck just happened? I thought this board is here to grant variances for things that are against the city code. But Tom, you made it perfectly clear. If it's against city code, you got to deny. So I feel sorry for the Olsons here. I mean, if that's the standing of this board, you have to deny them. But I certainly hope you don't. I certainly hope there's some common sense in this room. What they're asking for is not outrageous. It doesn't impact the city, it doesn't impact the neighbors, and it's going to improve their property values. There is no downside to this. You should definitely grant them a variance. And if you do, then I formally request this board to go back and have a look at what happened to us back in July, because there was some shenanigans going on. And there's people in this room that know that for a fact. So if you grant them a variance, I think you could look back and realize you made a mistake and you should have granted us a variance. And if you do come to that conclusion, you just might be able to also honor my request for reimbursing Julie and I for the expense that we've had trying to meet the city code. That's all I got to say about that, except good luck to the Olsons.
May I respond?
Yes, Tom.
You had other options, though.
Wait a minute. We were denied simply because it was against city code.
For the way you
that
wanted
was
it.
your doing, Tom.
For the way
Simply
you
because
wanted it.
Right. Yeah.
If I could just jump in here, I don't think we should relitigate what happened.
Okay.
Right. No.
right.
And, you know, one of the other options was that we could take down a 100-year-old bur oak and move to the back, right? Well, that wouldn't have caused that much of an economic hardship, but I'm 74 years old. You know how much of a hardship that would be for me to try and bring down a 100-year-old bur oak and make room for a garage when there wasn't any reason for it? We were asking for a variance in our backyard, not impacting the city, not impacting the neighbors. The neighbors actually requested or sent a letter saying they were, in favor of us getting it. But like I say, there were shenanigans going on. We were sitting out there, and I could see Ward Phillips making motions and talking to people and pointing, and everything was going on in here. There was something not quite right.
Jim, you call that, you said enough. We understand.
I have.
But this is the hearing on the Olsons.
On the Olsons, good luck.
You've got other avenues to go if you want to have that option. Anybody else here wants to be heard? Second call, anybody wants to be heard? Third time. Is there any rebuttal by the petitioner or by Allison?
Sorry, unmuting here. Thanks, Jim. So I have kind of gone over what the current problem is here, what's going on with this property, and why they were denied. So they're 3 feet off from meeting code here. I will say that the homes on South Broad Street are historically all non-conforming homes. There are only a few homes that meet current setback requirements in the front yard. But my position here, if I'm just being black and white with this, is that the code states that there should be a 25-foot setback in the front yard, and this applicant did not meet that 25-foot front yard setback. They're very close to meeting it. I don't think that the expansion of the sunroom would hinder any neighboring property owners. I don't think that it would hinder, I don't think it would hinder us to accept a variance like this because they're not moving outside of the footprint of the home that's already existing. They're not going any further than what's already there. And they are not encroaching on any other neighbor's property. And the addition would not create a larger degree of nonconformity, nor would it create any unnecessary crowding. However, at this point, our ordinance does state that all homes should have the minimum of 25-foot setback. So with that being said, I would leave it at the board's discretion to decide if they would like to proceed with this variance or not, because our code does state that 25 feet should be required. And I would leave it at the board's discretion at this time. I don't have a recommendation.
Mr. Chairman, could I ask a question?
Yeah, go ahead.
Okay, Allison's, Chris Gary calling. I'm not sure if you can see me or not, but I just wanted to clarify one item that I think the petitioner raised, and I think she indicated that every other property on the street is less than the current setback that she has. Is that correct?
7 of the 9.
7 of the 9.
There
So
are 2 that are over 25 feet.
okay, and my question for you, Allison, is the city does allow for lot averaging generally, right?
Generally, yes, with the abutting properties only. So when we first looked into this, I was hoping that we could take setback averaging into account. However, with the verbiage of our code, it says that we can only take the setback average of the abutting properties. And as the applicant stated, unfortunately, the only 2 properties that meet current setbacks are on either side of this property.
And under the code, if this had been a situation where the existing houses were elsewhere, you could have actually gone down to a 15-foot setback. Is that right?
Correct.
Okay.
As low as a 15-foot setback, yes.
So in that sense, a 21-foot setback, which is what's being requested here, is still within the parameters of what the code would allow, depending on the configuration of what was already out there.
Correct. 3 houses down, they may be able to obtain a 15-foot front yard setback.
Okay. So in other words, I guess what I'm just getting at is the setback reduction that they're asking for is not something that would otherwise be prohibited under this lot averaging section.
Yes, that's correct.
Okay. And if I could just speak maybe just very generically before the board decides. I mean, as we've had some presentation here about what the variance process is for, and it's necessarily a parcel by parcel sort of analysis. I mean, no 2 parcels are the same, and that's kind of why this process was created. So you do look at the individual factors for each specific property, and you apply it separately. So I understand that there's been concerns about what happened previously. I wasn't here for that. I don't know the back record there. All I can tell you, though, is the fact that one decision was made in one case doesn't necessarily carry over to a subsequent case because all properties are different. So for purposes of what you're considering today, you look at what's been requested, you look at the factors that have been raised, You look at whether there's unique conditions of the property that are involved here. You look at whether or not the hardship is self-created, that type of thing. And then based on what you find, if you decide that the variance is warranted, then you grant it. If you find that it's not, then you don't.
But any comments or input from the board should be held for deliberation in a closed session, or?
No, you wouldn't have to, I mean, it is, you do have a closed session on your, I think you,
Yep.
yeah, you do have the option of having closed session on your agenda, so you could do that if you wanted to.
Don't have to.
You don't have to, no.
Okay. In other words, if I want to make a comment, I can.
Correct.
Okay. I am well familiar with South Broad Street. I've lived here all my life. I used to play baseball in the street on Broad Street in the 40s and 50s. But I know the area, and I did check it out twice this last week. And on that side of the street that the Olsons live, 115 South Broad, there are 6 buildings. The farthest one to the north belonged to the Lancer family for 70 years, and that house is 20 feet off the lot line. The next one south is 105, and that is also about 20 feet. And if you stand down on the property of Rural Insurance, I believe it is, and look up the street, 105, the second building, their steps goes out 4 feet, at least 4 feet past 115. The third house is 40 feet behind the lot line. The fourth house being 115, the house is 25 feet, but the steps come within less than 25 feet. And south of that is the Rural Insurance Building that used to be the Wisconsin DOT. That's about 40 feet behind the lot line. But then a house on the corner that was built probably in 1890 is only 8 feet off the property line. So there is no conformity on that side of the street as it is. So in my opinion, if that was 21 feet, it would conform with what's on the rest of the street. And that's my opinion. Now, you can move to go into deliberation, or if somebody wants to make a motion, either approve or disapprove, we can do it without going into deliberation, but
I would just say that if, to the extent anyone's going to make a motion to either, if it would be to deny, then it would be because you felt the standard wasn't met, or if the motion was to grant a variance, then it would be for the reasons stated on the record and in your zoning administrator's report.
I would prefer to see a determination that the existing front of that house is established street yard, and that's what dictates the street yard for this parcel. And that's not what I heard outside of the meeting before, so I'd like to get it on the record, that you're telling me that the established street yard is not what's from the front of the existing structure to the street line, it's what's the minimum required setback.
Well, it's 25 feet, basically, is the setback, yes.
It is the setback, it's not what's physically in the, that's been there when the zoning ordinance was adopted, that the front of that house was set at 21 feet from the.
The current house, as I understand it, is legal nonconforming, which means that it was legal at the time it was built, which I don't know, how old is this house?
It was built in the late 1800s.
Okay, so, probably predates any zoning, frankly. But if it was a legal structure at the time it was built, then it maintains that status even if the zoning code is subsequently changed to build in bigger restrictions. So this house is what we call a legal nonconforming house.
But the definition of the front street yard, which it isn't in the ordinance as street yard, it's called the front yard, but the front yard isn't defined anywhere in our ordinance, so I think it's implied that it's the street yard. You're telling me that the street yard is 25 feet, whether the house, as it was established when the zoning ordinance was adopted, is 21 feet? That doesn't.
No, the
make
fact,
it street yard. Okay.
so with respect to street yard and front yard, I can tell you a lot of codes are notoriously inconsistent in how they use those terminology, but generally street yard and front yard are synonymous. But again, what the current code requires is a 25-foot setback. But this property, because it was constructed before the code existed, is at least legal nonconforming.
and the deck was on the house when they bought it in 2000.
That's what I've heard.
And all they're doing is closing in the deck, basically.
That's what I've heard.
Correct.
But the decks are allowed to encroach into yards, I believe. Is that not also true?
I don't know that would depend on your code, and I don't know the answer to that offhand.
I believe you can encroach up to 6 feet into a yard with a deck, with an open deck. They have a little bit different, requirements for structure.
But it looks like the house itself actually protrudes as well, right?
Yes,
Okay.
but that was my point. If the protrusion on the house is 21 feet, if that, I mean, but I was told that it's 25 whether the house is there or not, so. And I think-
It gets confusing, but it is, for new construction, if anyone was to build a house now, it would be 25 feet, or whatever lot averaging applied.
Well, the thing
But
is,
for pre-existing
the
structures. it's
city
different.
never established a historic district, but that is recommended. That's part of the historic district, which you run into the problem where there's no conformity prior to 1950. Okay, anything built after that in this town is pretty much 25 feet. But in the older sections of home, you can go down South Church Street, South Broad, South Washington, South Wisconsin, or South Lincoln for 2 blocks, and there's absolutely no conformity on any of those blocks.
Yeah, again, that's not uncommon, and the way the law addresses that situation is with this
So-
legal non-conforming status that we talked about.
If we don't know, we need to go to a closed hearing or to a closed session. I would move that because they're enhancing the building, they're improving the building, and they're gonna increase the value of it, which is gonna raise their taxes. But I would move that the grant the variance to build their addition as per the specs submitted to the commission, to the zoning officer.
And would you add that that's for the reasons that you heard during the hearing tonight?
Right.
Okay.
Is there a second to the motion?
Second?
I would ask for a roll call vote because it has to be 100%, does it not?
Can
No, I
we-
don't believe it's you require 4 votes for your variance.
Do we have to establish the other parts of the variance, that there has to be a hardship? I mean, are we just granting everybody the option now to move to 21 feet on that street?
Well, I think they want to put the addition on to kind of,
I can, if you'd like, I mean, that's why I added the language about what was discussed previously. If you want, I can try to summarize what I heard during the report tonight. If you want to flesh that out, we could do that.
yeah,
I mean, what I heard was that the structure itself is currently a legal non-conforming structure, meaning that it's less, the existing structure is less than 25-foot setback. There was a mention of the hardship that the applicant's actually experiencing in terms of a relative. There was testimony, I think, from the applicant that there's an existing deck there, so this is just enclosing a structure that's already there. There's not a new encroachment that's, in other words, not coming any closer to a property line. And then there was discussion about the fact that lot averaging would normally apply here, but it happens that the 2 properties on either side of her are actually at 25-foot setback, even though the rest of those are not. So those are the notes that I had.
okay. Roll vote?
Sacco,
Yes?
Boardman,
Yes.
Welch,
No.
motion's carried 2 to 1.
I'm just pointing out that the code says you have to have 4 members to approve a change,
We only have 5 members on the board, I believe,
right?
and
Aren't you?
2 are not here.
I'm not a board member, no.
No, 2
Oh.
are not here.
So we only have 3 members.
3 out of 5.
We can't approve it then tonight. It's got to get tabled. Oh, I thought he was on. Oh, jeez.
So does it have to come back to the appeals board again?
In practice, it's going to have to be, I mean, the application won't have to be filed again. But at this point, we don't have enough members to actually be able to vote on this.
So you don't have a
You
quorum.
have to have 4, so all
I
5
mean,
members.
you could choose to act tonight and you don't have enough members to act. But the issue is if you don't have holding the hearing when there wasn't even the possibility that could be approved, kind of defeats the purpose of having the hearing. So I would recommend either tabling it and having, do you have one or two other additional members that would normally be here? Do you have a full,
Two.
do you have a
This
full
is-
roster of?
We have two, but we were told that 3 out of 5 is a quorum.
3 out of 5 is a quorum.
Okay.
But in order to approve a variance, you need to have 4.
Okay.
So in practice, without a fourth member here, there was no way this could have been approved. So I would recommend either that we table it and those 2 members who are missing review the transcript, and then they can come back and you guys can have, at your next meeting, you can cast a vote, or we can have another public hearing at that time and go from there. But in practice, with only 3 members here, it's one of these real quirks in the statute. It is technically a quorum, so you can have a meeting, but when your code requires, in fact, let me just make sure I got that right. Allison, you may know offhand, do I have that correct, that you need 4 members to grant the variance?
I believe you're correct, yes. Mm-hmm.
Correct. So since it turns out there's only 3 members here today, in
So-
practice,
So we'd have to adjourn the meeting and recommend a
Table.
Table it
table
until
it,
the
yeah.
next.
Yeah, then the
Until we have
applicant,
another meeting.
right, so then she wouldn't have to refile anything, she wouldn't have to pay any additional fees or anything, but it would just be tabled until we're able to get at least 4 members here.
Okay.
So we need a
Okay.
motion to table.
Motion to table.
Second?
All those in favor?
Aye.
Opposed? Motion carried.
From a legal perspective, we're not required to complete another public hearing, because we have all of the Board of Appeals members here, other than the 2 that are missing. Is it possible to talk about a date that we can table it to and schedule another meeting?
Yeah, you can definitely discuss scheduling.
Um,
You have a quorum still, you just don't have a sufficient number to approve a variance.
okay. Is there a specific date, in mind that might work for everyone here that's present to get this rescheduled?
When is the next plan
Potentially-
commission meeting? Do you know, Allison, offhand?
Well, I think it should be rescheduled as soon as possible, so.
The next plan commission meeting would be scheduled November 16th. However, we don't have anything. But we could still hold a Board of Appeals meeting on November 16th. If that might work for the
It
members
works for
that
me.
are present.
Works for me.
Good.
The 3 present are for that, so.
Did you want to see if it works for the applicant too, if she wanted to be present, or?
What time?
What time?
5 o'clock.
Oh, pardon? 5?
5 o'clock.
We have one member that may not be able to make a 5 o'clock meeting. That's why she's not at this meeting.
Yeah.
Do we need to go later, Sherry?
Yeah, I think so.
Well, if that's a separate meeting, let's make it at 6, and we'll make sure Desiree is here, because she works and doesn't get off until 5.
Okay. We will not have a plan commission meeting that night. So we could make it 6 o'clock because it will not conflict.
Hey, Allison, you may have to have a planning commission meeting that night because of the ETZ, so the planning commission may have to appoint the members to the ETZ board. So we got to get some clarification from our council on that, but that's our understanding.
Are you talking about the town of Sugar Creek?
Yeah.
Okay.
Is it a membership?
Okay. Okay, any chance then I want to get this meeting scheduled, and because a public hearing isn't required, is there any chance that next Thursday, November 9th would be a possibility?
I wouldn't be able to make it.
Okay. We can stick with the 16th then, we may just have to say 5 PM.
All right, so this meeting would be adjourned and rescheduled for 6 o'clock on the 16th of November, correct?
5 o'clock.
5 o'clock.
5:30?
Could you,
Can that member
could you
make
do
it at 5
5:30?
o'clock?
I mean, that way Desiree could possibly be here.
Yeah.
Otherwise, you may end up with the
We-
same situation.
Yeah, we could do 5:30, or we could also do 7. It's whatever works best. I'm open to that, either or.
5:30 or 7.
Well, so if you don't have anything on the agenda for the planning commission meeting, except for potentially one item that probably is not going to take a terribly long period of time, you could always do 6:30 on the 16th.
Okay. So we have some flexibility. Can we tentatively set it for the 16th, and then I can ask other Board of Appeals members what time might work well, and then we can schedule a.
I think you said at 5:30 you wouldn't have a problem, but at 5 you might.
Okay, we can do 5:30.
Nothing else, meeting adjourned.
We need a motion to adjourn.
Motion to adjourn, okay.
So motion.
Second.
So moved.
And we had a motion over here.
Okay, second.
All in favor?
All those in favor say aye.
Aye.
Aye. Opposed? Motion carried.